I'm Cynthia Rowland, and this is episode 151 of EO Radio Show. Today, I'm joined by my colleague Joe Hilliard with our review of the common pitfalls faced by charities and foundations that wish to withdraw from the California Registry of Charities and Fundraisers. That department of the AG's office was previously known as the Registry of Charitable Trusts. By way of background, a California nonprofit corporation that decides to stop operating and wind up operations must take certain steps. In California, the procedures to voluntarily wind up operations are called dissolution of the nonprofit corporation. Dissolution can be accomplished by either filing an action with the Superior Court or, more typically, by complying with the voluntary dissolution procedures under California corporate law. Similarly, a foreign corporation, that is, a corporation incorporated in another state, but having had operations in California or formally solicited California residents for contributions. Sometimes these foreign entities cease operations in California and want to discontinue operating here and withdraw their registration from the California Registry of Charities and Fundraisers. In today's episode, we'll talk about the mechanics of dissolving or withdrawing. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Today, I'm joined again by Joe Hilliard, a senior paralegal here at Farella. Joe specializes in formation and compliance matters for all manner of entities, and in particular, he helps me with charities that are exempt under Internal Revenue Code Section 501c3. Welcome back, Joe.
It's good to be here.
So today, I thought I'd start our episode about withdrawing from the Registry of Charities and Fundraisers with a fun fact. This actually just came in this morning's advance sheets. There's a little bit from Caitlin Noble, one of the senior attorneys in the California AG's office, who's focused on the registry and other compliance matters for charities. Anyway, she noted in a recent materials that in California, the regulation of charities actually started with a particular case involving a for-profit organization. And in fact, something near and dear to my heart, and that is horses. There was a horse racing racetrack here in Northern California in San Mateo County known as Bay Meadows, and it was holding charitable events. It was increasing attendance by attracting women and children. Now, we all know women, children, and charities often go together, as Caitlin noted, though she isn't sure why. Anyway, she notes in this article that Bay Meadows was holding charity days, and the money was going, supposedly, to various charities, which would have been fine. It's okay to bet in California on the outcome of a horse race. So apparently, it turned out that the money did not, in fact, go to charity. It went to purchase a new racetrack in Washington state. This was way back in the 1950s. There was a public outcry, and the Registry of Charitable Trusts, as it was then known, was formed in California to regulate precisely this kind of relationship between charities and fundraisers, or the people who were representing themselves as fundraisers for charities. So I thought that was really interesting that this all started with a horse race.
That's pretty cool.
Before we really get into the nuts and bolts and the pitfalls, I thought I'd mention for listeners that the AG's office actually has a really good website on dissolution mechanics. The easiest way to find all of these materials is to just search Registry of Charities and Fundraisers and then just walk your way through the pages. But if you want to go directly to the dissolution site, it's OAG for Office of Attorney General, oag.ca.gov/charities/dissolution. And at that page, you'll find YouTube dissolution webinar and a delinquency webinar, and then some tabs that describe the summary of the voluntary dissolution process, how to dissolve nonprofit corporations or terminate trusts and withdraw from the registry, and then links to the actual laws and regulations and some frequently asked questions. So a lot of that sort of stuff we're going to cover here, as well as some in-depth, practitioner tips that we've learned, in some cases the hard way, over the years.
Yes, no, for sure. Some of these the hard way, as we've things sometimes drag out more than you would like with these. But
yeah,
I will second that, especially much like how we recommend the podcast to people for a quick update. The two webinars that are on there actually are very good. The AG's office did do a very good with those. I've watched them when they put them up about a year and a half ago when they updated this and did that, and they are actually very good videos. And two, we will put the link to that dissolution page in the show notes as well today.
Absolutely. So, Joe, let's walk the listeners through how the domestic charity or foundation that is incorporated. We're going to focus first on incorporated entities because once you understand all that, it's really easy to talk about how to wind up a charitable trust. Let's start with the domestic corporation that wishes to dissolve. Walk us through it, Joe.
Right. And for sure, just a reminder to us, domestic means that they were formed here in California. So we'll talk about that first. And so there are a lot of very common pitfalls when it comes to withdrawing the nonprofit from the AG's office, and especially if it is that nonprofit. The top level is you can't dissolve a California-formed nonprofit with the California Secretary of State until you have what they call a dissolution waiver letter from the AG's office. And that's where it starts. You can start before you even make it to requesting that waiver from the AG. So our first starting point is your board members, the board of the foundation, the board of your charity will need to finalize and approve a plan of dissolution. And this plan will need to include naming a final grantee that has current tax-exempt status with the IRS and with the California AG's office, and subject to a written agreement requiring that the distributed assets be used solely for exempt purposes within the meanings of Section 501c3 of the IRS Code. Best practices here would include a current bank statement in that plan of dissolution, noting the current finances, and then an unsigned copy of the completed form from the California Secretary of State, which they call the Nonprofit Certificate of Election to Wind Up and Dissolve. Kind of a mouthful. We kind of call it the wind up form here, the dissolution form. So once the board has signed off and approved the plan, then that election document can be signed and needs to be signed and filed with the Secretary of State. And again, this will need to be signed by all board members. This is a Secretary of State rule. When you're starting to close down the foundation, you can't really, we'll talk about when we get to the form, there's a slightly different way. It's easier, but in terms of a California one, all the board members have to sign off on it. And again, that's really your biggest concern, your biggest pitfalls you go for it is documentation. As we will see, the AG thrives on documentation before it approves this withdrawal for you. Because the letter requesting the Attorney General waiver of objections is pursuant to CalCorp Code Section 66716, it's all about that support documentation. So with that, we're talking about this. Once we've got the election filed, we've got our signed off plan of dissolution. Then as we talk about what we're going to send to the Attorney General's office, we're going to send current articles of incorporation and bylaws for this foundation. It sounds simple. And it sounds unnecessary since the AG has all of these on record from both your initial CT1 registration and best practice. Every update that you've done to them, any amended and restated, have been sent to the AG's office. But they're looking to have everything, the AG wants everything in one little neat package and presented to you directly right then when you're requesting the withdrawal. Okay,
great. So let's pause here on a couple of things about the articles and bylaws. It is really important, and this is a pitfall I see sometimes, that the articles and bylaws are actually consistent with the organization is trying to do. So, for example, if the bylaws provide that you can't wind up and dissolve without some third party, maybe the founder has to consent, you're still going to have to be in compliance with those bylaws and articles provisions. So that's really important when you're attaching the bylaws and articles to your request for waiver. Make sure somebody reads them and all the boxes are checked for what's actually required by the internal documents. So then moving on, what's the next item on your list, Joe?
So we hit it briefly, but once we talked about real briefly, you have to file that certificate of election to wind up with the Secretary of State, and that filed copy has to come back, and that has to be provided with your filing. It's a simple form. It's literally a one-page form that says all the board members have agreed to it. There are no finances. They're like two little check boxes, and then, like we said, the entire board has to sign off. There are two ways to go through that with the Secretary of State. I know we've spent a lot of podcasts talking about filings with the Secretary of State. Here for this, it either needs to be a wet copy of everybody's signatures, and they all have to be on the same copy. There is no counterpart availability for the state. We were talking about pitfalls that will get you, that we've discovered the hard way, that will get you being. This is one with the Secretary of State. We tried one once where there was one person that was out of the country, and we had them sign it separately and attach it, and it got bounced. They said, no, all of these have to be on the same copy. Yeah. But with that too, if you have, and again, most of the new ones, we do this immediately. We try to set up web portal access to the Secretary of State's site. And if you have that in place, again, with the exception of older ones, which we don't necessarily have, we try to get that in place. You can actually do this via email. So whoever promulgates the form online through the Secretary of State's web portal then adds all the board members' email addresses, and they all get an email from the Secretary of State and it goes, yes, 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 and it's approved. And then literally as soon as the last board member signs, you are filed, you get your filed copy back from the state. So it's actually faster in the long run as long as you have an email savvy board and the Secretary of State doesn't go to your spam, which is, that's another question entirely. That's another podcast entirely when we talk about spam from federal agencies, and state agencies.
Okay, great. So next step. So again, going back to what we are going to provide to the Attorney General with our request waiver letter, they want to see current financials. And they want them to note that the nonprofit is winding down. So best practice here are copies of the nonprofit's most current filed IRS 990 and the AG form RRF1 for the last fiscal year they completed. And then obviously the date, if they've been through already the date they were approved by the AG. You can pull copies actually off the AG's website to see when they've approved them. They will stamp them approved on their website. So that's usually best practices. Go to their website, make sure they've already got that in place. Pull that specific PDF down as an exhibit. Yeah. And noting that the California AG is actually pretty prompt about getting the 990s and the RF1s up on their site pretty quickly. The IRS is very slow these days, but the AG site we've seen is pretty quick at getting them up there, right?
Yes. We'll talk about that later in terms of if they're not as quick to do these withdrawal requests, but in terms of that, usually you would say within probably 60 to 90 days, you will see your approved RRF1 up on their site with the stamp on it. So yes, that part works actually very fast. But then again, too, it's not enough just to have those current filed documents to the AG. They also want to know where your current status is right now when you're requesting this waiver for the termination. The best practice here is to include a current profit and loss statement for whatever current year you're in today. So right now we're filing, it's mid-March 2026. So at the best, you should at least have one through the end of February of 2026 that you're attaching if we were doing the letter right now. And then the request letter to the AG will attest that the current assets of the nonprofit, what the current assets of the nonprofit are, and note specifically that these statements describe the cash, the office equipment, program-related investments, and all their investment securities. One pitfall here is that should the AG deem there's too much cash, they may put this on a hold and they will ask you for further financials. I know, Cynthia, you and I have had this, but at the end of last year, we had one where this came up where there seemed to be too much money and they wanted to see that.
They want more. Yeah, and note that these are not audited or compiled or, and there's no magical way that these financial statements need to be reviewed. It's at that short time lag. It's almost always internally generated list of assets and P&L for the time period since the last tax return.
You're correct.
Yeah.
We don't generally do audited ones at this point.
Yeah, and you don't need outside attestation or anything. It's just the request to the AG specifically has a statement under penalty of perjury, but you don't generally want to mislead the AG's office about anything when you're asking them for approval.
We haven't got to that part, but we're going to attach this board plan of dissolution already, and that had a bank statement attached to it. So they will be seeing a bank statement at this point either. And I guess this is a good time to talk about security and concerns. We would always recommend either way that you redact, obviously, your bank account number on that statement and anything else that seems confidential. But by the same token, unlike the RRF1, this request for withdrawal is not a document that will be available on the AG's website. This is strictly internal. The only thing that will go up is when they finally give you the approval waiver letter. That will be the only item that's on their website. So I know it sounds scary. It's like, I'm putting my bank statement with all my stuff out there. I'm putting all this up. But really, it's going to be stuff that's in the background that will not be in the public purview. And then with that, as we're talking about what else needs to go in the letter, we're going to attest that after payment of debts and liabilities, it intends to distribute its assets according to the plan of dissolution. We just said that. We're going to attach the plan there. And following from the plan, then in the letter itself, also, we will repeat some of the language that we have in that plan, namely that the nonprofit will attest that it has reviewed the final grantee named in the plan, verified its tax-exempt status, and that all distributions were made subject to written agreement under 501c3. That's basically what they want to see is that there. And beyond this attest, though, and what we don't necessarily have in the plan, the letter request will need to include the full legal name, address, phone number, EIN, California Secretary of State ID number, and the AG registration number for who your final grantee is. They really want to see that this goes back to where you're talking about with why it started in the 50s, because they want to know that you're actually sending it to a real other charity. You're not just pocketing the money or sending it out somewhere else to a nonprofit.
If it is a charity, if the distributee, and it can be more than one distributee, it doesn't have to be
Correct,
one grantee.
Yes.
They don't have to be in California and they don't have to be registered. But if they are required to be registered in California because they have operations here, then the AG is going to want to see that they're registered. Unless the dissolving organization's purposes clause requires that the assets remain in California, they don't actually have to go to a California registered charity. But again, this goes back to checking your purposes and your own dissolution clause to make sure that where it's going is a permissible grantee.
Correct. And like I've got one going not with you, but with one of the other attorneys here where the final donee is actually one of the tribal nations here in California.
Okay, that
so
counts.
Same thing, that you have slightly different language. And obviously I don't have to give much more than say, here's the tribe and here's their name,
right?
And that they meet the requirements as a tribal organization. So there are obviously exceptions to that. Yes.
Yeah. Good note.
With this, Stu, as we're talking about though, if you identify someone, they do want to see a copy of that final grantee's articles of incorporation and their IRS exemption letter, their determination letter. And that can give you heartburn. We've had a couple of nonprofits lately that wanted to distribute to an older nonprofit from the 60s that didn't really have their letter. And when you go to the IRS website, they don't keep their determination letters, only go back probably 15 odd years. So that actually held us up for almost a month while we were trying to find some way to get it. There's a way that you can request a duplicate style letter from the IRS, but that takes several weeks. So that was there. So, and again, so the big issue here is as any of these items not being produced can cause the AG to not grant the withdrawal and ask for more documentation. We talked about the financials, but there are other things that could come up with that. And when you respond with that updated documentation, it restarts the processing time. You go back to the end of the line. It's not like, say, when you're at the DMV and you go, oh, they just fill this out, and you fill it out and you go back to, you're back near the top of the line. You've gone back to the end of the line. And that leads really to, which again, here at a law firm especially is the biggest pitfall, not having enough patience with this process. We all want to have this done as quickly as possible. And like I said, at current here, it's March 20th. The AG on their website notes you can request an update in 90 days. And at current, the real-time response, though, for an actual yes or no to your letter is close to 6 months. Last request we've got a response to is one we sent in late July 2025, and the approval of the withdrawal came back the second week of February in 2026. And we have one we did in the third week of August of 2025, and we have not got a response yet on that. And again, these were relatively simple. So that's it. Patience.
Yeah, well, and planning ahead. So for an organization that wants to dissolve in 2026, you better get started right now.
You should have started last week.
Yeah, exactly.
Unfortunately, is what we would say.
It just takes a while because, again, to reiterate, you can't actually dissolve the corporation in California until you've got the AG waiver letter. And until you have the AG waiver letter, you don't want to close your bank accounts or distribute those final assets. And so there's going to have to be some wind-up time after the dissolution waiver arrives. So if you want this actually off the books by December 31, you've got to have that waiver letter maybe in October, late October, to give you November to get everything done before the holidays.
We talked about how we had to file the election to wind up. Mm-hmm. Once you get that waiver letter, then you file with an actual certificate of dissolution with the state of California. And it actually has to have that letter attached. You cannot file it, if you file it over the counter with just wet signatures, it will, you'll get kickbacked in 10 days when they've looked at it, and they won't even let you finalize and process it online unless there is an attachment of that letter to it. They will it won't even let you file it. It'll say, your filing is incomplete. So that's a good thing to remind. Yeah, exactly.
That's perfect. So let's shift gears a little bit and talk about the foreign nonprofit that wants to withdraw from California, whether it's dissolving or not, because its dissolution itself will be dependent on the corporate laws of the state where it's incorporated. But if it's been registered with the California Registry, it's very helpful to withdraw from the registry before you've dissolved in the other state.
No, for sure. Yeah.
And then after we talk about that, remind me, Joe, I want to come back and talk about some of the post-dissolution things that the board needs, some additional pitfalls. But anyway, before we get to the additional pitfalls, let's talk about the foreign nonprofit.
So for the foreign nonprofit, it is, yes, slightly different. Instead of that initial election to wind up and terminate, you will file a certificate of surrender. And this actually terminates the Secretary of State status as soon as it's filed. So that part of it is actually easy. And again, and unlike where we were talking about where it needs the whole board to sign, in this case, the president can sign or the treasurer can sign. A senior officer can actually sign the certificate of surrender. And this too can be done online, and it's just a single signatory. So it's not. And again, the attest, it's if you do print out, it's a one-page form, and it simply attests that you are removing yourself from the state. So that part actually is easy, but the AG still requires that same letter requesting and all the documents we asked for in the domestic. And the AG may still ask for more documentation before they withdraw the status in their database. So again, what you're looking at there is all of the stuff we talked about, your financials, your last filed, because even if the foreign is registered here, they're doing the whole thing. They're doing the RRF1 with the AG's office. They're filing their 990. So, and this goes both ways. You and I have ones where we've done this where we're actually dissolving it as an entirety. And we've also done where simply they're no longer doing business here in California, where it's just, we just want to surrender our California, but we've got one that's in Illinois right now that they're still doing stuff in Illinois, but all of their people have moved out of California and they're no longer doing business here. Yeah.
And that's pretty straightforward. When there's not been any reasons to investigate or concerns at the AG's office, they don't particularly care if an organization withdraws, if it's not subject to California jurisdiction any longer. But you do have to go through the process in order to get out from under the annual RRF1 filing requirements.
Right. Because otherwise they will mark you as a status, and they will try to find you and or you will see that on your status. It will be you will have potentially penalties on this. It's not as big as if you're here in California where you can't actually terminate your entity, but you will still have requirements until they accept this. So it's just good to reminder.
Yeah, and that's a good segue into the short discussion on charities that are organized as a charitable trust. Now, a charitable trust is not incorporated with the Secretary of State. They're not even legal entities, but it's a regulated charitable organization by virtue of holding assets in charitable trust and is required to register with the AG's office. So it doesn't have to go through this process with the Secretary of State to wind up and pay out all of its assets, but it's still subject to the AG's jurisdiction on what you do with those assets when you wind up the trust and the final reporting requirements. And the AG's leverage there is that once you're registered, they will expect to see the RRF1 form every year. And in order to get out from under those nasty gram letters that come every year if you're late, you're going to have to officially notify the registry that the trust is being wound up. And you provide exactly the same level of information. But what you don't have to do, and there's no reason to do it, you don't have to go through the Secretary of State filings, but you do still have to provide information to the registry of your intention to dissolve and show all the same financial statements and information about where the assets are going that you would do with the corporation. Any other thoughts on the charitable trust dissolution, Joe?
I think in the background with that is a reminder with that, and we're talking about post-dissolution things, is once that's been accepted, you should still alert the California FTB, our franchise tax board here, because even though you're not registered with the Secretary of State, they will, in the background, when you've registered as a charity, the AG will push through to that, and they will assign you an FTB number that's separate, and you can find those trusts on the FTB website, so they need to be alerted as well that it's there. I mean, in theory, the AG, the FTB will talk about this, but best practices here would still be to, as soon as you got that letter confirming that went, that you should then let the FTB alert. Again, whether they talk to each other or not, we always say this. It's like, yes, that will be a communication, but we should be the ones doing it. We should control that.
To make sure it gets done. And that brings us back to our favorite regulator, and that is the IRS. So there's two things to note there. After all the dissolution process has happened, the AG's waived it, you're withdrawn from the Secretary of State. That doesn't mean that the IRS knows about any of this. So,
correct.
Just like the final tax return with the Franchise Tax Board, a final tax return needs to be filed with the IRS. And all of this is after the fact. Okay, so you've wound up and dissolved as of December 31. You still have to file that final set of returns for the year ended, whatever year you just dissolved in. And that obviously is going to happen sometime in the following year. So you've got to have someone who's willing and able to stay on task and make sure that final return gets filed. Often the accountants can be paid in advance to file the return. So you pay that before you close your bank account. And then you make sure that there's an officer available to actually sign those last returns.
And again, as we're talking with the time here, if you're on a year end, we were just talking about this potentially now, you may not get it until January, February of 2027, which means you will have to do a short year, 2 month for 2027 as well.
If there's a lag time. Exactly.
Which is a heartburn, yes. So, but that's one of the things, again, why we talk about doing it sooner rather than later in the year if you're going to do it, because there's that time lag. You don't want to have to do So a short year.
Yeah, I didn't think about this when we scheduled doing this episode, Joe, but we are actually very timely. So for anybody who's thinking about dissolving, this is the start
This
time.
is your wake-up call for one of them.
It's like you better get started because it's going to take a whole year to get it done. The final thing I want to mention is that for private foundations that wind up and dissolve, there's actually a separate final filing with the Internal Revenue Service of a private foundation that notifies the IRS that it is terminating its private foundation status. And that's a very technical requirement. But if you're thinking of winding up and dissolving your private foundation, make sure you have that on your dissolution checklist to make sure that termination of private foundation letter is sent to the IRS at the end of the day. So I think that about covers it, Joe. And do you have any final thoughts?
No, I'm curious about that last one you just asked. So do you do that separate from like your final 990? Okay,
yes.
I think that was what I wanted to clarify. That is it's not doesn't go with the filing. It's something separate.
It's a separate filing that goes to a separate IRS address.
Okay, and perfect. That's good to know.
It's another one of those traps for the unwary. I mean, it's not like the end of the world if you don't get it done, but if you want to get out of the IRS mailing list, their follow-up list, you have to file that final termination of private foundation notice. And there's some technical details for that, but I'll save that for another day. So with that, Joe, thank you. I think we've provided a lot of pitfalls here that unfortunately we learned the hard way. And so hopefully our listeners will have a leg up on some of these.
Like I said, it's always good to tell people how things work, but it's also best to also often say, look, this is what can go wrong too. So I think this is a good one.
Yeah. All right. So with that, be sure to check the show notes for the links Joe and I mentioned. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Varela, Braun & Martell. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.